So good afternoon, everybody. Welcome. Good afternoon. Welcome to the 2016 Ronald H. Coase Lecture in Law and Economics. The lecture was founded in 1992 in honor of Ronald Coase, the Clifton R. Musser Professor of Law and Economics. Professor Coase joined our faculty in 1964 and remained a member of the faculty, eventually taking emeritus status until his death in 2013. In true University of Chicago style, Professor Coase was always intellectually curious and always intellectually engaged. At age 100, he was still publishing. In 2010, he published a new book, How China Became Capitalist, co-authored with Wang Nin. Professor Coase's most famous work, The Problem of Social Cost, published in 1960 in the Journal of Law and Economics, is familiar to all University of Chicago law students, or it should be. In fact, I think it's familiar to all law students all across the country, no matter where they attend. It, of course, grapples with the problem of externalities, and it contains the idea that eventually became known as the Coase Theorem. Happily, for lawyers, law students, and law professors everywhere, transactions costs are rarely zero. Professor Coase is also well known for his 1937 article, The Nature of the Firm, which considers why some economic activity occurs within firms and some economic activity occurs within markets. In 1991, Professor Coase received the Nobel Prize in Economics, making him the first law professor to receive a Nobel Prize in economics. The Coase Lecture honors Professor Coase and his contributions by creating an occasion for a member of the faculty to speak on a topic in law and economics. And I'm delighted that today's lecturer is Professor Dhammika Dharmapala. Professor Dharmapala is the Julius Kreeger Professor of Law. He serves on the boards of a number of scholarly societies, including the American Law and Economics Association, and he recently became a co-editor of the Journal of Law and Economics. He obtained his undergraduate degree at the University of Western Australia and obtained his PhD in economics from the University of California at Berkeley. In fact, his PhD thesis was awarded the National Tax Association's Outstanding Doctoral Dissertation Award. Prior to joining the law school, Professor Dharmapala taught at the College of Law at the University of Illinois at Champaign-Urbana. His extraordinary scholarship spans the fields of taxation, economic analysis of law, of course, and corporate finance and governance. Among the topics that Professor Dharmapala's research has considered is how the differential tax treatment of debt across jurisdiction leads to distortions in the patterns of ownership in multinational corporations. He's also researched topics such as how the particular features of corporate governance, such as board independence, mandatory disclosures, and the power of audit committees, affects the value of firms. Professor Dharmapala's topic today is the credibility revolution in law and economics. The topic is very much in keeping with the tradition of the Coase Lecture. In 1992, the very first Coase Lecture was delivered by our then colleague Alan Seitz on the topic in Introduction to Regression Analysis. So today we'll move beyond the introduction and we will welcome or despair the revolution. Please join me in welcoming Professor Dharmapala.
Well, thank you very much, Dean Miles, for that very kind introduction. It is indeed an honor to deliver this year's Coase Lecture and to join an illustrious line of scholars who have given this lecture. It should be noted that the Coase lecturers include Ronald Coase himself, who delivered not the first, but the 17th Coase Lecture in 2003. According to those who were present, Coase expressed a certain amount of puzzlement as to why he was given this task. He apparently said, any lecture I give is a Coase lecture. And he also felt a little bit of awkwardness at the fact that one of the purposes of this lecture series is to honor Ronald Coase. But we should not feel any discomfort about doing so today. So my topic is what I will call the credibility revolution in empirical law and economics. And what it will introduce is a set of tools that has emerged in recent years. Arguably, these tools hold the promise of fulfilling a prophecy of Oliver Wendell Holmes Jr. in his influential 1897 essay, The Path of the Law. You may recall that he said, for the rational study of the law, he argued the future belonged in part to those who had mastered statistics and economics, which is very much the intersection of what I'm going to talk about. So as many of you are aware, law and economics began as a primarily theoretical exercise, establishing a framework that could shed light on the impact of law on human behavior and on the content of legal doctrines. Both of which, of course, are very important, though I will focus a little bit more on the former because most of the applications of empirical analysis have been on the first of these. So this type of analysis, of course, inescapably leads to empirical questions. That is, it raises questions of how much law affects behavior, for example, in a particular context. And so such questions call inescapably for empirical analysis. And one might have thought that early law and economics scholars were in a fortunate position in terms of answering those types of questions because they could draw on an extensive set of empirical tools, indeed on an entire subfield of economics devoted to statistical methods known as econometrics. However, in the early days of law and economics, econometrics was held in some disrepute. A prominent econometrician, Edward Leamer, posed the question of how should we take the con out of econometrics. He said, he observed that hardly anyone takes data analysis seriously, or perhaps more accurately, hardly anyone takes anyone else's data analysis seriously. Around the same time, Sir David Henry of Nuffield College, Oxford, questioned whether econometrics was really a science or whether it was more akin to alchemy. Their concerns reflected widespread dissatisfaction with empirical economic research and with the credibility of the findings of this research. More recently, however, applied empirical economics has undergone what the economists Joshua Angrist and Jörn Stefan Pischke have described as a credibility revolution. Particularly since the 1990s, this attitude has been transformed within economics in recent years through primarily a greater attention to empirical design and causal inference, and the use of experimental and quasi-experimental methods. Perhaps paradoxically, this has been accompanied by less attention being paid to sophisticated statistical techniques. Rather, the emphasis has shifted to thinking carefully about how variation is generated in the real world. And this, I believe, creates a particularly strong congruence with the focus of law and economics. In particular, there's this very powerful analogy to randomized trials, then the division the division between treatment and control groups has been a particularly powerful metaphor in this revolution. So what I will do is provide a survey of these developments as they have been reflected in empirical law and economic scholarship, and I will illustrate them with a variety of examples. A few of these will draw on my own work, and I should say at the outset that these are chosen not necessarily because of their quality or value, but simply because I happen to be familiar with them. So I will begin by outlining two important pioneering empirical studies in law and economics, both of which were conducted here at the University of Chicago. The first of these was George Stigler's work on the regulation of securities markets, George Stigler being the 1982 Nobel laureate in economic science. and a professor at the Graduate School of Business across the Midway. I believe in that direction, but I'm directionally challenged, so I'm getting that wrong. So the second is a study by Isaac Ehrlich at the time of the Department of Economics on the deterrent effect of capital punishment. So the first of these, and I should say before I start that I will contrast their work with the way that later scholars have approached the same questions, but none of this is intended to disparage these pioneering contributions, which have shaped the field and framed the kinds of questions that we still ask today. So George Stigler posed a question that nowadays seems obvious with regard to the securities laws of the 1930s. So as you know, in the 1930s, Congress enacted the Securities Acts that created a regime of federal securities regulation based on mandatory disclosure. And George Stigler posed the question of whether this type of regulation increases the value of firms, or in other words, the amount that investors are willing to pay for shares, which today seems obvious but had not previously been systematically investigated. His approach to doing so was to compare the abnormal returns of new issuers, that is, their returns relative to a market baseline, in two periods, one before and one after the enactment of the securities laws. So his results were these. Let me just focus on one particular. What he found was that these new issues performed about equally well, or rather more accurately, they performed about equally poorly in both periods. About a year after issuance, they underperformed the market by about 20% in each of these two time periods. And so these abnormal returns were quite similar. Here is my attempt at a graphical representation of his results. So imagine that vertical line represents the enactment of the securities laws. That's the market return in the preceding period. That's the green line is the performance of new issues, and the difference is the abnormal return. We can do the same thing afterwards. He found those abnormal returns to be very similar, and in his view, this casts doubt on the value of securities regulation. From today's perspective, however, there were a number of shortcomings to this analysis. The most fundamental is the lack of a control group. For instance, of firms that were not subject to the securities laws. So if there were a hypothetical set of such firms in the post-reform period, conceivably they may have performed even worse. In addition, the securities laws may have influenced the baseline market value in the period after the Securities Acts, and his approach was not well suited to uncovering that type of effect. Despite these shortcomings, the question that Stigler posed continues to be of great importance, and later on, new opportunities arose to more credibly study the impact of securities regulation on firm value. In 1964, Congress enacted a set of amendments that extended the reach of the securities laws to many, but not all, issuers that traded over the counter, that's to say, not on an exchange. Two studies in particular have focused on this episode, one by Michael Greenstone, who is now the economics department across the Midway, and his co-authors, and another by Alan Farrell of Harvard Law School. In this episode, exchange-traded issuers were unaffected by these amendments, and so they serve as a natural comparison group in this type of study. The disadvantage, though, is that price data doesn't exist for over-the-counter firms in any easily accessible form. So this involved a considerable amount of hand collection by the research assistants of these scholars. here's Greenstone et al.'s results. These amendments were enacted in August of 1964, and the vertical lines in this graph represent the period over which they entered into force. And what we see is a divergence in the returns for over-the-counter firms that were becoming subject to these rules relative to exchange-traded firms. In all, the authors find large positive abnormal returns of up to 22% for the firms that became newly subject to securities laws. Moreover, Alan Farrell found a decline in volatility for over-the-counter firms relative to the control group of listed firms. Thus, when using these more credible comparison groups, it does appear that securities law is valuable to firms. Right, so to continue with the story, in subsequent years, Congress enacted additional laws relating to securities markets. The Sarbanes-Oxley legislation of 2002, for instance, imposed extensive new obligations on firms, including obligations related to their internal controls over financial reporting, known as Section 404B. These new obligations led to concern among policymakers that regulation had become too burdensome, leading to what is known as the Jumpstart Our Business Startups Act, or Jobs Act of 2012. Now, you will note that here Congress is following a venerable tradition of in which the titles of bills or their acronyms broadcast politically popular concepts such as jobs. For those of you who are familiar with the television comedy series Yes, Prime Minister, Sir Humphrey Appleby makes a rather similar remark with regard to the titles of government reports. So the Jobs Act created a new class of public corporations known as emerging growth companies, or EGCs, that enjoyed or that were subject to reduced disclosure and compliance obligations for a 5-year initial period, including exemptions from Section 404B that I mentioned before. There were two primary criteria to be an EGC. One was having less than $1 billion of revenue, and the other was first issuing securities to the public after December 8th of 2011. So the application of this rule was partially retroactive. Here's a timeline of the events surrounding this act. Most importantly, from March 1st of 2012, it was known to the market that if the legislation were enacted, it would be backdated. Its application would be backdated to December 8th of 2011. Subsequently, the House passed the bill by a large majority, but then opposition began to grow. The New York Times described this as a terrible package of bills, apart from which, they seemed quite positive. On March 15th of 2012, a major new development occurred in which the Senate Majority Leader, Senator Reid, who had previously been lukewarm about this act, described it as a measure the Senate should pass expeditiously and should consider expeditiously and pass in short order. At that point, it became much more likely to pass, and thereafter the bill proceeded on its merry way through the House, Senate, and presidential signature. So in a forthcoming article with Vic Cunner of the University of Michigan, we used these two different thresholds, the $1 billion of revenue and the December 8th, 2011 date, to set up an empirical design of the following type. We find data on firms that went public over the relevant period. So the EGCs here are in this quadrant here where we have between 25 and 41 firms, depending on the exact date. And then we compare those to a group of firms that went public in the months immediately before December 8th of 2011. Here's a graph showing the abnormal returns across those days for the two groups of firms. The treatment firms that were affected by the reduced disclosure obligations are in a color that one might call royal blue. The control firms are in a color that one might call University of Chicago maroon. So right around March 15th, we see a positive abnormal return for the treatment firms. And so what this suggests is that the market responded favorably to these reduced disclosure obligations. So how does that fit into this wider story? Well, it seems from the earlier studies I've described that securities law is very valuable to firms relative to a baseline of little or no regulation, but it is possible to have too much of a good thing. And so relative to a baseline of very extensive regulation, it is possible that, that investors may react favorably to reductions in disclosure obligations. So now let's turn to the second of the two pioneering studies. Isaac Ehrlich was writing in the mid-1970s. The context was the Supreme Court's Furman decision, which ruled that existing death penalty statutes were unconstitutional, and its subsequent Gregg decision, which upheld certain death penalty statutes in 1976. Now, although Ehrlich's results were not directly relevant to the legal questions considered in these cases, the Solicitor General Robert Bork cited Ehrlich's work before the Supreme Court, and certainly the finding that the claim that he had that each execution deterred 8 murders was of great public interest at the time. He relied on time series analysis, that is, national level analysis at the national level of homicide rates and executions over time, particularly in the 1960s, to make his case. This was his sample period, and you can see that a negative relationship between the execution rate and the homicide rate is apparent in the latter part of that period. It is much less apparent if you look at the entire, at a much longer sample period, as was pointed out by a panel of experts convened by the National Academy of Sciences to critique Ehrlich's work. Now, you might think that the students among you at least might think that the researcher's worst nightmare is to have a panel of experts assembled by the National Academy of Sciences to critique one's work. That's not completely clear, though. Scholars strive for influence, and it would arguably be worse to be completely ignored than to be condemned in this way. There is a saying among scholars that any citation is a good citation. However, the National Academy of Sciences did not highlight what we would today view as the major flaw in this analysis, which was the absence of a control group. In later work, Donahue and Wolfers used Canada as a control or a comparison, where they looked at homicide rates in the United States and Canada over various periods during which the availability of the death penalty varied in each country. And what they found was that the US and Canadian homicide rates moved very much in tandem regardless of the availability of the death penalty. In other words, it's very difficult to detect any deterrent effect here when using a credible control group. So the importance of control groups then is an important lesson from what we've just discussed. Note also that much of this variation, as I mentioned before, is based on changes in the law. So law in economics is thus in the position of playing quite a central role potentially in the credibility revolution, not just in within law and economics narrowly, but much more broadly. So in the remaining time, I will introduce a few examples of different methods of causal inference, including experiments, field experiments, and what we term quasi-experiments, those studies that use, for example, treatment and control groups or sharp discontinuities in legal rules and the like. To start with experiments, one of the best-known experimental studies in law and economics was of the foundational idea of the Coase Theorem. Now, Dean Miles has already said that the Coase Theorem is familiar to every law student at the University of Chicago, so I will not bother to explain what it is. This experimental study was by Hoffman and the pioneering experimental study was by Hoffman and Spitzer in 1982, and what they did was to have experimental subjects play either the role of a controller, person A, and a second party, person B, where the controller chooses the level of an activity. For example, the number of head of cattle in Coase's famous parable of the farmer and the rancher. But of course they can bargain, and so what Hoffman and Spitzer tested was whether the parties achieved the efficient outcome through bargaining. And a quick glance at this table will tell you that the efficient outcome here is this. And indeed, parties do achieve the efficient outcome, as Hoffman and Spitzer found. However, they also found something a little bit more puzzling from the perspective of the law and economics, which was that the most common pattern of payoffs that parties agreed to was 7 to A and 7 to B. Now, of course, if we look back to this table, we'll see that if A were to simply walk away from the bargaining table, A could ensure a payoff of 11. So we would think that the bargaining outcome should give A at least 11, but that wasn't how these experimental subjects seem to behave. Okay, so moving now to field experiments. Field experiments are studies that use randomization to generate treatment and control groups, but are conducted in the real world rather than in the laboratory. So one particularly important line of work using field experiments uses matched pairs of testers or auditors to measure the prevalence of discrimination in society. While this is not directly a legal question, it is, of course, very relevant to how we think about anti-discrimination law. The pioneering study in this area was by Ian Ayres and Peter Siegelman. Their study on fair driving involved dispatching 300 different pairs of matched testers to car dealerships, where they negotiated over the price of a new car. And these testers varied by race and gender. And here's one of their tables, which shows that in 85% of the outcomes, the African American tester ended up with a worse outcome. Now, these types of studies have become much more widespread, but one challenge they face is that it's very difficult to ensure that testers are completely identical apart from their race or gender. The tester's own knowledge of the study that they're engaged in may affect the results. So subsequent work in this area has tried to minimize or eliminate the role of the tester. For instance, Marianne Bertrand of the Booth School of Business across the Midway, in collaboration with Senthil Mullainathan of Harvard, sent out identical resumes with some of which randomly were assigned distinctively African-American names, such as Lakeisha and Jamal. And what they found was that those resumes with those names had a 50% lower callback rate. So the answer to the question they posed in their title, "Are Emily and Greg more employable?" appears to be yes. Finally, Doliak and Stein, in a more recent study called "The Visible Hand," went even further in reducing the role of testers. They sold iPods over the internet, and they varied randomly whether the iPods were pictured, held by light-colored or dark-colored hands, as follows. Oh, I'm sorry, it was supposed to be a picture of that, but it didn't appear. But so the iPods held by dark hands received offers that were 12% lower. The sale of iPods over the internet has become something of a cottage industry among empirical scholars. So Yair Listokin of Yale uses a similar technique to explore a fundamental question in contracts. So how do contracting parties interpret contractual silence, which obviously has implications for whether the default rules of contract law are majoritarian. So what he did was to sell Apple iPods on eBay and randomly varied the warranty terms. So this picture did come out. So this is a picture of an Apple iPod Nano, and so Listokin randomly varied the warranty terms with these various options, or he maintained silence about the warranty terms, which of course leads to or entails that the contract law default, which is the explicit warranty of merchantability, would prevail. And he tested how the price of these Apple iPod Nanos varied by the warranty term or silence. Encouragingly, he found that a silent iPod sold for about the same price as one which explicitly specified the contract law default. So finally, let's turn to quasi-experiments. And let's start with the topic of corporate governance, which is a major area of scholarship across a number of disciplines and has become a major area of focus within law and economics. In its survey by Atanasov and Black of corporate governance research a couple of years ago, the authors identified 863 empirical studies in major journals over this period from 2001 to 2011. Methods of causal inference, though, seem to have made only a relatively small impact. Of these 863 studies, only 75, less than 9%, used what the authors viewed as being credible methods of causal inference. One of these was a study by Black, Zhang, and Kim in the Journal of Law, Economics, and Organization in 2006. And what they did was to use a law in Korea that created a sharp discontinuity in the legal requirements for firms with assets that exceeded a threshold of 2 trillion won. And here is a picture that depicts their findings. TQ here is Tobin's Q, which is a measure of firm value. On the horizontal axis, we have the asset size, and the vertical line represents the legal thresholds for the application of these stronger requirements. And what they discovered was that there was a discontinuous jump in firm value at precisely this threshold. And they argue that this can be interpreted as a causal impact of these legal requirements on the value of firms, right? Something that would in the absence of this type of sharp discontinuity or threshold would be a difficult claim to make. Along similar lines, in work with the same co-author, Vic Khanna, we studied a set of reforms in India known as the Clause 49 reforms, which imposed new requirements for disclosure and board independence. And they applied to firms that met a size, essentially a size threshold that was defined in terms of these concepts of paid-up share capital and net worth, which referred to the initial capitalization of the firms when they went public. Initially, this was a change to the stock exchange listing agreement, and the penalty was merely delisting from the exchange. Subsequently, however, in 2004, Parliament enacted severe penalties, including criminal penalties for violations, as is known as Section 23E. And so here we are comparing the value of the average value of firms affected by these reforms, the solid blue line with the dashed maroon line, which is the value of firms that were unaffected by the reforms. And we see that in 2004, at the time of the enactment of the severe penalties, we see an increase in the relative value of affected firms. We also see here a discontinuous jump in firm value at one of these, at the net worth threshold, suggesting again the causal impacts of these legal reforms on the value of firms. Moving to a rather different area, there's a large body of empirical work in public finance or public economics that analyzes responses to taxation. Typically, this work uses changes in tax rates as a source of variation. However, there are other features of tax law that can also help us generate credible empirical estimates. For instance, in my work with Foley and Forbes on multinational firms, and in my work with Desai on the effects of dividend taxation on investment, which I will talk about very, very briefly now. So in that study, we used a 2003 law enacted by Congress, which reduced the tax rate on dividends from on dividends received by U.S. individuals from about 40% to 15% for dividends that were received from U.S. corporations or from foreign corporations that qualified for this treatment based primarily on whether there was a tax treaty between the United States and the country of domicile of the foreign corporation. To the cognoscenti, this law was known as JUGTRA, and its full name was the Jobs and Growth Tax Relief Reconciliation Act. So once again, we see Congress following its tradition of putting all of these politically popular things, jobs, growth, and tax relief, all in one, on the title of one piece of legislation. So this is a very successful naming effort by Congress. Here, dividends from non-treaty countries, countries without a tax treaty with the US, were unaffected, and so investment in these countries serves as a control. And what we find is that US investment did indeed increase both absolutely and relative to the control in treaty countries after this law was enacted in the post-JUGTRA period. Now, one concern here is that it is quite possible that there was a pre-existing trend towards greater investment over time in treaty countries. So to investigate that, we look at the fraction of U.S. investment, that is of equity foreign portfolio investment, to be precise, but of the type of investment that we're interested in, the fraction of that investment that is in treaty countries. And it turns out that that was generally declining over time, except when this law was enacted. So that suggests that pre-existing trends are unlikely to explain this finding. And this also illustrates a much more general point about this type of research, which is that Causal inference requires typically that treatment and control groups experience the same or experience parallel trends prior to the change in the law. Otherwise, there are differing pre-existing trends that cast doubt on the causal impact of the law. Now, that is generally true. However, as our very own Professor Milani has argued in work with Julian Reif on tort reform, it is possible that what look like pre-existing trends may actually represent the anticipation of the reform. So let me give you an example. On the vertical axis here, and Professor Milani can correct me if I'm wrong here, but on the vertical axis we have a measure of the supply of physicians in a state, and on the horizontal axis the number of years relative to adoption of tort reform by a state. And it looks like that there is a pre-existing trend in the year before the reform is adopted. But Milani and Reif argue convincingly that this is actually due to physicians' anticipation of tort reform, so they start moving into a state in the year prior to the reform being enacted. Okay, so let me briefly note another very important strand of quasi-experimental research in law and economics, which uses the random assignment of judges to federal appellate panels as a source of variation. Since this is arguably random, although say Professor Chilton has some work investigating the extent of randomization further, but the general view is that this is randomly assigned, and so we can view that as quasi-experimental variation. This literature has found a number of intriguing results, one of which is about peer effects on judicial behavior, where the composition of the panel affects how judges vote. So one possible explanation for the existence of peer effects is that there may be more deliberation in panels that are heterogeneous in terms of the party of the appointing president. So our very own Dean Miles has investigated this question further. So his argument is that if peer effects are indeed due to increased deliberation, then mixed panels that are heterogeneous in terms of the party of the appointing president, should take longer to render their decisions. However, he finds no evidence of any difference in the speed of decisions. More recently, or even more recently, I should say, Daniel Chen and Susan Yer have used the random assignment of judges to study the drift of or changes across different circuits in takings doctrine over time. And their argument is that since this is generated by random assignment of judges to panels, that it can arguably be viewed as quasi-experimental, and they study the impact of changes in takings law and particularly expansions in government's eminent domain powers on a variety of different outcomes. They find higher economic growth and property values. They find adverse effects on minorities. This has been a very quick tour through the field of quasi-experimental study and causal inference in law and economics. So I want to conclude with a few thoughts. The first, I think, most important point is that recent developments in empirical scholarship have, I think, greatly enhanced the credibility of the findings of empirical law and economics scholars. This is, I think, important for law and economics itself, but law and economics also plays a very important role in this credibility revolution, because so many of these quasi experiments come from variations in the law. And I think what this suggests is that law and economics scholarship will continue to move, as it increasingly has, in an empirical direction. And one might hope, at least, that this holds out the promise, on the one hand, of greater influence on policy making. If we can provide more credible estimates and of empirical effects and do so in a more unified way, as opposed to having various conflicting findings, then perhaps policymakers will listen more carefully. However, one should be cautious about being overly optimistic on that score. After all, we live in an era when populist politicians seem to believe that they know more about climate science than do climate scientists. Secondly, there's this growing concern that legal scholarship has become increasingly interdisciplinary, and to that extent has less to say to practicing lawyers than it did in the past. One possibility of empirical scholarship, I believe, is that, especially where it uses credible methods of causal inference, that interdisciplinary scholarship that is empirical can perhaps be of greater relevance to practitioners as well, by telling practitioners something concrete about the world that is relevant to the law. This is, of course, especially the case when doctrinal questions turn on empirical issues, but perhaps it's also true more broadly. At least that is my hope, and so let me end there, and I welcome any questions.
Some people criticize some of the credibility revolution in law and economics, actually economics generally, as having shifted the focus on something called internal validity, away from external validity. And the idea is, in order to make credible causal claims, one has to have certain conditions prevalent, control, frequency, things like that. And those are not common. And when you find them, you make causal inferences that are relevant to contexts where those conditions are prevalent. And it's very hard to make inferences about situations where those conditions are not prevalent. And so what we're really doing is sacrificing external validity for internal validity. Another way to put this is, places where we see randomization are so rare and uncommon that we can't learn very much about what else is going on in the world in some of the areas where there's randomization. So how do we properly balance those two concerns?
Right. So that's a very, very interesting question. It's essentially pointing to this problem of the drunk looking for the keys under the lamppost, since that's where the light is. And I would say that there is very much a danger of focusing on those questions that can be those narrower questions that can be answered through quasi-experiments or experiments, as opposed to perhaps the bigger questions that cannot be answered using those methods. On the other hand, I would also say, though, that outside of the context where we are fortunate enough to have quasi-experiments, there isn't really very much that we can say in a credible way. So I think the answer to that is to acknowledge that where there are no quasi-experiments, we don't know very much, right? But whether or not we study the areas where we're fortunate enough to find quasi-experiments, for those other areas we're not going to know very much. So we should try to find out as much as we can about those settings where we can do credible causal inference, but we shouldn't claim too much in terms of extrapolating to those other settings. Simone?
Should be extremely interested in the essentially, I mean, this trend toward empirical methods in line economics is creating an externality on the theoretical line economics. Because I'm extremely concerned by the proportion of it. And you know, my work is mainly empirical, but I'm concerned that, I mean, now if we look in journals, I mean, the proportion, I think it's 80%, 20%, even probably more than 80%. And I'm just reporting the concern of one of my mentors, Alan Swartz, that he tried to react a couple of years ago, 2-3 years ago, with an association of theoretical line economics, that just to counterbalance, I mean, the offensive approach of empiricism.
Right, so two great points. So the first one, I completely agree with you about economic versus statistical significance, or I suppose more broadly, sort of economic or social significance, or financial, or whatever the issue is. I would say, though, that one of the consequences of this credibility revolution is that with stronger empirical designs, it is possible to place more weight on the magnitudes that one finds. It is now possible. So it used to be that researchers who found null results would give up at that point because they wouldn't be able to publish their findings. But nowadays, if you have a strong design, then you can and you find a very small effect, but a very precise small effect. I think that is much easier to communicate to others and to perhaps to policymakers as well. So I certainly agree with that. Now, I tend to be a little skeptical of policymakers' interest in a lot of this work, but I agree with the general point that we should focus on these magnitudes a lot more than we do. The rise of larger data sets has also made the issue that you highlight of statistical significance a little bit less critical, in the sense that with a large enough data set, you can get statistical significance, and the entire question in effect is really about the magnitude. Your second point is about this negative externality of the rise of empirical law in economics on the theorists, and we very much honor the theorists. You know, without theory, there would be no framework to guide empirical work. But having said that, one point to bear in mind is that in physics, which we all view as a very mature science, consists mostly of experimentalists, of empiricists, with only a very small fraction of physicists engaged in theoretical research. So there is a view, which I don't necessarily endorse, that a movement towards empiricism is actually a sign of the maturity of a field. But having said that, I fully recognize the importance of continuing to foster a certain amount of theoretical research. Dean Miles?
I want to follow up on that question and ask about whether or not what are the sources of this credibility revolution. One way to think about it is that the revolution is bringing a particular set of empirical methods, a particular set of experimental designs into law economics, and as a result, the inferences you draw now are more credible. But I wonder whether or not these empirical tools can be applied in contexts outside of law economics. So in recent years, has emerged a sort of separate academic society, the Society for Empirical Studies. So it's empirical and concerned with causal inference, but completely unmoored from law economics.
Yes.
So I'm wondering, what is the relationship between these two things? And in particular, I'm wondering because when we look at certain social sciences, there are some, such as, not to single one out, but to single one out, social psychology, which involves experiments, usually in a laboratory. So we think that's an ideal setting, so the experimenter can control it and can set up experiments that will allow for ideal causal inference. But in fact, what we see in that discipline is a real credibility crisis, because something has gone wrong there about replicability of experiments
Right. So let me start with the first question, which is you talked about the sources of the credibility revolution and the relationship between between empirical law and economics and empirical legal studies. I would see, and as you say, they historically arose from different sources. One could view empirical law and economics as importing techniques from adjacent areas from applied areas of economics. And empirical legal studies is a quite different origin, starting with the empirical study of the courts, and is, if anything, more related to certain other social sciences, such as political science or sociology. So I would say, firstly, though, that empirical methods are empirical methods, and that they need not be tied to any particular discipline. So and I think that's also somewhat true of credibility in empirical research. That the standards for credibility should be fairly common across different disciplines. It's the theoretical frameworks, going back to a theme that Simone raised, that differ across these different disciplinary backgrounds. So I would view empirical law and economics as perhaps a subset of the broader field of empirical legal studies. Although empirical legal studies is not so much a field as an approach. However, empirical legal studies is linked to theoretical law and economics in a way that, of course, the rest of empirical legal studies is not. So I think that's how I would characterize the two of them. And the second point is about credibility, even in a setting where there's this well-developed tradition of experiments, laboratory experiments, and the issue of replicability. This is something that's of particular concern to me as someone who has just begun editing a journal. So one of the approaches that has developed both, I think, in economics generally and in law and economics is the increased sharing of data. So it used to be the case that people would have their data sets and they would publish their findings, and the data set wouldn't necessarily be accessible to anyone else. Today, journals are increasingly demanding, requesting or demand somewhere on that spectrum that those who publish in the journal make available their data sets to be placed online and to be made readily available to others who wish to replicate their findings. So I think that's one response to that set of concerns. So just at the back, Adam.
So, as you pointed out, we've had this credibility revolution, and the main way that empirical work has gotten more credible is to focus on cases where we have variation, and that variation is as is random, right? So, put it in clinical terms, that we have people assigned to a treatment and a control group, and the way that they were assigned to that was pointless, would be the ideal set. Now, the problem that we have for those of us that care about law is that most of what law strives to do is first be uniform in its application, that is, no variation, and secondly, not random, that is, we want it predictable, and we want to give advance warning to people in advance what group they're going to be in. So in other words, we're striving to avoid the conditions that are good for causal. Now, this leaves us with a choice. Either we might end up chasing increasingly idiosyncratic or bizarre research designs, and this is, I think, what Anoop got out with his question. We have a generation of econs students that are chasing things that are weird instead of things that are important to find questions. Or the second option might be to increasingly work with policymakers, with private actors, et cetera, to create our own variation. Like, for example, I guess I mentioned him a sentence ago, but Anoop working to give some people health insurance. Something like this. So which direction do you think that we're going to go? Are we going to chase weird questions, or are we going to create our own variation?
Right. Well, so we're on the horns of a dilemma there. Now I agree with the point you made at the beginning that law strives for uniformity, but of course it often has some sort of de minimis threshold, and that's what some of the studies that I described try to exploit. It gives that kind of variation exists, even though everyone has perfectly clear notice about which group they fall into. Now, as to your primary question, I think there is a danger of idiosyncratic research designs, or at least research designs that pertain to idiosyncratic contexts. And then it seems like we have a choice between saying something fairly credible about some very idiosyncratic setting, as opposed to saying something rather incredible about a more important question. And that's a very challenging dilemma to have. But I think Adam just pointed to one way out of this, which is to design social experiments, to design our own variation. Now, in certain areas of economics, like development economics, randomized controlled trials have become commonplace. But I think that doesn't completely deal with this challenge of the idiosyncratic context, because it's easier to design randomized control trials in certain settings than in others, and to deal with what you might call lower stakes questions that policymakers are willing to let you vary, as opposed to larger stakes questions that they're less willing to have you interfere with. So I think that danger still exists, but I do think that it's probably the future direction is probably the second one, which is to try to design our own variation to an increasing extent, and we see that emerging in a number of fields. Martha?
I want to go back to Newt's question. I think there's a tendency in all fields to think that if you can't do something by a precise experiment, then you don't know anything. But actually, there are other approaches to knowing. And, in philosophy, there are experimentalists, and they do say, well, you can't know anything until you do an MRI of the brain and so on. But in fact, there are modes of humanistic argument that over the centuries have actually produced a lot of understanding of important questions. And that's also true in development economics, I think. So that if you just ask the question, what can we measure, you might end up studying a rather small set of development issues, but when you measure in the experimental sense. But on the other hand, normative ethical argument gives you a lot of insight into what people are striving for and what we should be striving for when we try to improve their lives. So I guess I'm just saying that we shouldn't forget that there are many, many ways of coming to know something, and not all of those are true experiments.
Right, no, absolutely. So as an empiricist, I would say that there are more things on heaven and earth than are dreamt of in our philosophy. And I fully agree that there are these other modes of humanistic inquiry, of introspection, and so forth that tell us very, very important things.
I mean, it's not just,
Yes.
intuitive and squishy. There's a lot of rigorous argument.
Indeed. Absolutely. So there's a lot that we can learn about the world through these methods. I have focused more specifically on what we might call questions of how much. Right? How do we trade off one thing against another? How much will behavior change if we change this set of incentives? And I think those questions, there was no attempt to suggest that those are the most important questions necessarily, but they are an important set of questions. And I think this talk has been very much about how we can answer questions of how much. Henri?
So I have to admit that when I came down, I didn't remember the title is The Credibility Revolution or The Credibility Crisis of Empirical Economics. So let me suggest two reasons why, the revolution is not always all that, promising, at least in my mind. One is if one were to do a very simple empirical analysis of the correlation between the authors of these studies put on paper, either the political, what they would like to find, or what they predicted just as being good, theoreticians, I bet you that we would find a positive correlation. I find that to be troubling, and I thought that the example we started with discussing, very interesting discussion of the example of Isaac Ehrlich and the aftermath, Wolfers and Donahue have produced some set of insights about the Ehrlich effect. Others have produced a contrary one. All have used quasi-experimental and sophisticated methods of control. Nevertheless, the results differ, and they often have to reflect their underlying politics of the writers. That's one thing. The other reason why I was a little bit concerned with the credibility of some of the empirical economics is a problem that we all know, is that the journals don't publish null results. And so there's a great incentive to keep trying and finding the right specification and design that will generate a publishable, surprising result.
Right. Now, those are great points. I would say that your concern about ideology or politics would be even more serious in the absence of a credibility revolution. That is, if we didn't have widespread agreement as to what was a quasi-experiment, then people have even greater leeway to find results that are consistent with their priors. Now, having said that, I think what the credibility revolution does is it does provide a way to decouple the ideologies of researchers from their findings. I think at least in combination with certain other developments, such as the increasing posting of data online, which allows others to replicate findings and perhaps to reveal the fragility of results. One suggestion, one important new innovation in this area is by Ben Shahar and Chilton, who have proposed the idea that researchers should, before they collect their data, should reveal to the scholarly community their methods and so in advance of any findings. And then and in fact you have done this with an experimental study. So I think that's one possible approach to take. Your point about null results, I think, is also valid, but I think the situation was even worse prior to the credibility revolution. So, as I said in response to Simone, when one has a credible design, it is easier to publish a null result as long as it's reasonably precise, because the design is strong enough that a null result really means a null result. So I recognize that these are all very, very significant problems. My rather modest claim is merely that the credibility revolution makes some progress in addressing them, not that it solves them completely. Yes.
So I guess especially in Chicago, when we talk about empirical studies, so we usually apply quantitative methods. However, I wanted to ask if you think that qualitative methods of research can be relevant for large econ at all, and in which ways?
Oh, absolutely. Well, there's a number of very important studies that use participant observation or various qualitative methods, interviews and so forth, that have been extremely influential in law and economics. I would cite, firstly, Bob Ellickson's The Cost of Coase and Cattle, where he essentially used anthropological methods. There's studies of, you might be familiar with the study of stand-up comics. Why do we see so many stand-up comics despite the lack of intellectual property rights and jokes? So I think I have not talked about qualitative methods, mostly because I am not particularly adept at them, but that's not to say that they cannot make a valuable contribution. It's more of my shortcoming rather than the methods. Richard?
How do we know that you use the word revolution, and I'm just curious, how do we know it's revolution as opposed to incremental improvement? So 10 or 20 years from now, will people look back on the difference between what's going on now and Isaac Ehrlich and others and say, oh, that was a revolutionary change? Or that was just a sort of normal science improvement in method?
Well, I think that's a question of judgment, and it depends on how far away you stand. It is entirely possible to view all of these developments that I've talked about as being more evolution than revolution. To be honest, I borrowed the term credibility revolution from Angrist and Pischke. I think that the claim is that there was a qualitative transformation. Prior to this set of developments, right, this alleged revolution, there was a steady progression of towards greater statistical complexity and the use of more and more sophisticated statistical methods. The credibility revolution was different in that it is a fundamental change in focus from statistical theory to looking carefully at variation in the real world. And so it was, in a way, it was turning away from the prior path of development. So I think that's the sense in which it was a break from the past. But I think one can view many of these developments as being incremental as well.
So please join me in thanking Professor Dharmapala, and please join us for a